works with CASL, works with PIPEDA, so very relevant to everybody in the room. I've known Trevor for a long time through the privacy community, and I'm really excited to see what you have to say for us today. And apologies for coming in late, but you're on. You're good to go.
Thanks for the introduction, Matt. I'm learning a lot attending this, and I'm delighted to be speaking in the regulator slot. I know in previous summits you've had the CRTC here. I think the suggestion was this time it would be a nice change to have the OPC. I thought it would be useful, as we haven't spoken at the summit before, to just kind of set a base level of an understanding between the intersection between Canada's anti-spam legislation and our federal private sector privacy law, the Personal Information Protection and Electronic Documents Act, or the PIPEDA, or whatever you want to call it. So it's going to be a mixture of a refresher for the old hands who've been around a while, and maybe a 101 for some of the newer people. But before I start, I just want to state that while I have nearly 17 years experience at the OPC, I'm familiar with CASL program for like 11, 12 years, and with PIPEDA, and I've been asked to share my knowledge with you guys at this summit. The following presentation does not represent a statement of the OPC's official position on the enforcement of the Act. It's my comments. It's been looked at and reviewed, but my comments. So, what am I going to cover today? Okay, so I'm going to first of all kind of take us down memory lane and look at CASL's initial amendments to PIPEDA in 2011. Later amendments to PIPEDA in July 24, when most of the provisions of CASL came into effect. I'm going to tell you a bit about how we work with our CASL enforcement partners, the CRTC and the Competition Bureau. I'm going to look at some previous OPC investigations with regard to email and spyware. I'm going to look at what relevant guidance we've got for businesses doing e-marketing and obtaining consent, and what we've got for individuals. I'm going to look at how we kind of triage email and SMS marketing related complaints that come into the OPC, and also some recent OPC activities that may be of interest to your industry around AI principles, privacy principles, data scraping, and a recent regulatory sweep we did of deceptive dark patterns in online sites and apps. So, okay. Initial amendments to PIPEDA. So CASL was enacted, received royal assent in December 2010, and it introduced almost immediately a whole bunch of amendments to PIPEDA. So I've got them listed there. These are not all of them, but these are kind of, I guess, what we consider the most consequential. So the first one was it gave the Commissioner an enhanced ability to decline to investigate a complaint from the get-go. There's 4 grounds in the Act which cover that area. It gave the Commissioner the ability to discontinue an active investigation. It's about 8 or 9 grounds for the ability to do that. But the ones I'm going to pinpoint, really the last 2, which is the ability to share information and collaborate with our domestic provincial counterparts, privacy agencies across Canada, Section 23, and equally our ability to work with our international counterparts under Section 23.1. And these last 2 amendments, if anyone knows anything about the OPC, have had a huge impact on our capacity and what the work we do to deliver enforcement outcomes across the globe. So privacy and spam knows no boundaries, and such collaboration between data protection agencies used to be rare, but now it's the norm. We have several investigations that we've gone public with, that we're doing joint with our provincial and international partners, and others that we haven't gone public with. So what you see is just the surface of the iceberg. Okay, so most of the main provisions under CASL, which affected the CRTC, the Competition Bureau, and our office, came into effect in July 2014. So over 10 years now. Pretty amazing to see how time flies on that. The amendments to PIPEDA were limited. I give all the sections throughout my presentation and lots of links to documents and that. So to try and save you a little bit of time, if you want to look up things. So the first one was Section 7.1 split into 3 parts. So basically, the first part is just definitions. So what's an electronic address? So electronic mail account, instant messaging account, any similar accounts, so social media, messaging app, kind of thing, that kind of thing. SMS text would count under that. The other provision, subsection of that is the collection or use of electronic addresses obtained with the use of computer programs. So really, we're talking about address harvesting in bulk, scraping websites, web crawlers, that kind of thing, or an email address generation. The other subsection is 713, which is the collection or use of personal information through any means of telecommunication by accessing a computer system in contravention of acts of Parliament. So we see that as we call that the malware spyware provision. Now, what is important to understand is that with these changes that came in July 2014, they didn't actually introduce any new privacy contraventions under PIPEDA. All they did was set out that we could always investigate spam spyware issues under PIPEDA in the past using the existing consent provisions and principles, and we'll cover some of these older cases for a little later on. But what the changes from CASL to PIPEDA did do was that they just clarified that if an entity, an organisation is conducting commercial activity and collects and uses the personal information of individuals in the ways just described, so address harvesting and spyware, then they can't avail themselves of the exemptions to consent under the rest of the Act, which kind of makes sense. If you're going to be scraping addresses, or you're going to be using spyware to collect people's information without their knowledge illicitly, then you can hardly go along and then claim, oh, OPC, you can't touch it because we've got an exemption under PIPEDA. We blasted the rest of PIPEDA, but we're going to try and use an exemption in PIPEDA. So that isn't going to fly. So that's just a brief history about changes to PIPEDA from CASL. So let's talk a little bit about how we work with our partners at the CRTC and the Bureau. So the Act CASL itself is very clear that consultation between the enforcement partners to ensure effective regulation is a requirement. It's not a nice to do, it's a requirement of the Act. And sections 58 and 59 set out how we can do that. So how we can share information, how we can work together, collaborate, cooperate in investigations. There has to be a written agreement between the parties, and there's a limitation as to how we can use the information that we share. So it has to be, for the purposes of an investigation, not just, kind of collecting the information for the sake of it. And that's all set out in the CASL Memorandum of Understanding between the OPC, the CRTC, and the Bureau, which is on each of our websites. It dates back to, I think, 2013, actually predates the July 2014 changes. So what that means in practice is, some of you may be familiar with the Spam Reporting Centre. This is operated by the CRTC and is a central repository of spam and other electronic threat reports that come in from the Canadian public. So they can go to the fightspam.gc.ca website, which is maintained by Innovation Science and Economic Development Canada. And there's a form that they can complete to report the kind of things that they're encountering, the spam that they're receiving, or they have the ability to forward a report with the actual kind of spam connected to it. So we get kind of two routes of information: the actual forms completed, and then the forwarded spam to us. And they also have other sources of information like data feeds that they collect. And our three agencies all have access to that Spam Reporting Centre. So, and by the way, I would recommend, if you haven't seen the Fight Spam website, to take a good look at it, because it covers a whole ton of information, the agency's responsibilities, how to report spam, how to forward spam, and it also it includes a lot of resource information, the legislation, the regulations, etc. Now, we also share communications and outreach activities, so we frequently compare who we're speaking to, what audience we're speaking to, in conferences, webinars, blogs, social media messaging, etc. like that. And actually, my attendance at this summit is a very good example of that, because it's the CRTC that put us in touch with Matt, and the reason why I'm here today. We also work together on what's called the CASL Performance Measurement Report. So that's a year-by-year kind of digest of our activity over the year. And these are public. So these are published on the FightSpan website. So if you go to resources and you click on the resources tab, you'll see one of them is the previous year's reports going back, I think, to about 2017. And then, of course, all three agencies are members of various regulatory networks, which kind of crisscross each other. And the two obvious ones are the Unsolicited Communications Enforcement Network, or USENET. And we all attended the morgue session, the first Monday to Thursday. And we're also all members now of the new Canadian Digital Regulators Forum, which was formed last summer, which was designed to harness our collective knowledge and expertise and strengthen the work of all three agencies so that we can better respond to the scale, speed, and global nature of digital markets. So we've got some stuff. There's some stuff on the Competition Bureau website because they were the chair for the first year. And there's year 1 and year 2 reporting. So year 1 is what we've done, and year 2 is what we're planning to do. So that's on the OPC website as well. So please, feel free to take a look. But we're concentrating at the moment on AI and getting up to speed on the knowledge and what's out there. So I said I'd look at a few investigations. So first of all, I'm going to look at a couple of investigations that predate CASL's main provisions coming in July 2014, and I'm going to look at a couple after. So the first reference here, the unsolicited email from marketing purposes, they date back. Admittedly, it's 2005, that's a long time ago. But the reason I include them is it's actually two different cases concerning the collection of business email addresses, one from an employer's website and one from a professional association's membership list, respectively, and the subsequent use of those addresses to send unsolicited emails unconnected to their profession or business, unsolicited emails without consent. And that's despite limitations being put on the use of these emails by the employer and by the professional association. So they were still collected and still used, and people were still spammed. Now, while these old cases and PIPEDA's provisions regarding what constitutes business contact information have been amended in the subsequent years, I think these cases are still instructive as to how our office views such emails. The second one is a spyware case, pretty shocking, even now when I reread it. So this was where we investigated the Canadian franchisee, or one Canadian franchisee of a US rent-to-own company called Aarons Inc. So for low-income families who maybe can't afford a brand new computer, just buy one out of store, they can rent to eventually own it. And what happened was, unbeknownst to these clients, is that each time they took on a computer, rent a computer, there was this spyware application that was installed on the laptop computer, detective mode. And that was to allow them to covertly track laptops that may go missing, or people stopping payments and trying to track back the laptops. Now, this software could be installed remotely activated as well. So it wasn't just secretly installed, it could be remotely activated. And it was designed to collect keystrokes, contact information, screenshots, microphone, webcam photos, as well as other information. Now, we found that successful activations of the software resulted in the collection of hundreds of pages of records of individuals containing all kinds of sensitive personal information, including pictures that could be taken if the computer was in a children's bedroom, and like all kinds of horrible things. And this was even unconnected to the people who maybe originally rented the laptops. So, people would rent the laptops would go missing, people would stop payments, and somehow new people would get control of the laptop, maybe it's being sold to them. And this software is continuing to collect the information of them. Now, our investigation also revealed that when the software was activated, the franchisee had no way to control or predict what information was being collected. It would just collect everything. So we found that the resulting loss of privacy was obviously disproportionate to the benefit of tracing the laptops. So the franchisee promised to delete all such information and never use this kind of software again. So there's a couple of pre-CASL investigations where we did it under PIPEDA. So a couple of post-CASL investigations, and Matt and I were talking about the first one a little while back at Morgue. So the first investigation we did under CASL, and it's one that CRTC did as well, was a commissioner-initiated investigation into a Quebec-based training provider called CompuFinder. And this was as a result of, I think it was close to 1,000 reports in the Spam Reporting Centre about this company spamming people. So CompuFinder was harvesting email addresses before CASL came in, but continued to use those harvested email addresses after CASL came into force. So that's what we caught them on, the second part, not the first one. They stopped collecting these, harvesting these email addresses up to CASL and then said, oh, you can't touch us. But oh, no, we can, because you're still using emails in these campaigns. So that's what we got them. I won't go into all the details. It's a pretty lengthy report. It goes into a lot of detail about all the various things they were using, including misleading telephone scripts, collecting scraping information off websites where there's explicit statements saying you can't use this without authority, you can't do this without authority. They were saying that they were collecting information and using the information to send emails to people about their training courses, which had no relevance to their specific profession or business. They were unrelated. So we got them on many counts, but what was interesting was that with the recommendation we made, the company complied with all our recommendations. So we got a good result. And I thought this one, the second one here would be interesting because of the COVID connection. So in the second case, this individual arrived from an international flight at Montreal Air, and he was required to undergo COVID testing in accordance with the public health rules, Public Health Agency of Canada at the time. He had no choice. They were the only company doing the testing at the airport. So he said that he provided his email address for the sole purpose of receiving the test results, which kind of makes sense. It's a mandated program. He has to go for testing. He wants the results. And of course, that's linked to quarantine and that kind of thing. But he later started receiving promotional emails about the use other private health services used by the testing company. So the company explained to us that they initially considered that they had a business relationship with these travelers, these arriving travelers, and it could assume their implicit consent to send these promotional emails. But we disagreed, respectfully disagreed, because in such a situation, clearly the travelers had no choice. This was a government mandated program. They had to go for testing. They had to provide their contact information. But it could not reasonably be expected that they would start to receive marketing information. So the company, to be fair to them, reacted very quickly, admitted that they had other complaints of this nature. So they voluntarily deleted all these kind of emails from the marketing database and stopped the marketing quite quickly. So in addition to action investigations, we do other activities together. And I just want to briefly mention one that we did in November 2020, which was the CRTC, the APC, and the Bureau issued a joint letter, a joint statement to the mobile app industry in Canada to basically remind them that they had to comply with CASL. So we included a legislative overview of provisions, and we gave examples of mobile app practices that might potentially represent violations of CASL, and basically stated, informed them that they were in a unique position to detect, prevent, and stop such activities. And we invited them to review their procedures, and if they were not up to scratch, to make changes to those. So that was just like a bit of an awareness raising letter, a bit of a warning letter shot across the bows, just to take a good look at their compliance with CASL. Turning briefly to relevant guidance. So we have some stuff on our website. It was a little dated, but it's been modified a bit more recently. So we have a guide for business doing e-marketing. And this is just aimed at helping businesses comply with PIPEDA when it comes to address harvesting, email activities, that kind of thing. And it just examines some basic things like who's responsible for what under the Act in relation to e-marketing, how PIPEDA's provisions affect businesses conducting this marketing, third-party e-marketing, companies doing it on behalf of their clients, the importance of consent in collecting electronic addresses, the potential cost of spam to your reputation, etc. Steps businesses can take to avoiding contravening PIPEDA, and a few hypothetical case scenarios. We also have some guidelines which are not specifically aimed at e-marketing, but they're just general guidelines on obtaining meaningful consent. And the reason I include these is meaningful consent is a core essential element of our privacy law in PIPEDA. And the second document here, this document here, sets out practicable and actionable guidance that businesses should follow to ensure they obtain appropriate consent under PIPEDA. And I recommend that you review it, you look at it carefully, and you know what it says, because we now regularly examine organizations' compliance with these guidelines whenever we receive or conduct an investigation into a consent matter. We, regularly, all the time, keep reviewing back to the guidelines. Did the company follow the guidelines? If they didn't, where didn't they, and so on. So that's a kind of standard. If you get a consent complaint, we're looking at those guidelines, almost guaranteed. I'm going to skip that, the guidance to individual. I'm just going to say here, in the interest of time, to show you where it is and what it is. Okay.
Sorry, can we share these with everyone after the slides?
Oh, yeah.
Okay.
Yeah, that's been approved. That's okay.
You just can't email it to us.
Sorry.
I can. Everyone who showed up gave consent.
Yeah.
I haven't implied consent for that.
Actually, I thought it would be useful to you guys to see what kind of email and SMS text complaints we're getting in and how we triage. So, if you think about the CASL amendments to PIPEDA, by their very nature, address harvesting and spyware, while they pose threats to Canadians, they're going to be difficult to detect. I mean, Canadians are not likely to be complaining about those, provisions, about that specifically involve those issues. Identifying such instances is going to require an intelligence-based approach to investigations. It's not going to come from Canadians. What Canadians are going to complain about, and what we see each year, is a relatively modest number of direct complaints from individuals concerning email and text marketing. And it involves recurring themes, which I think I looked at Steve Haroon's fireside chat from the 2022 summit. Consent and unsubscribe, no surprises. So receipt of such marketing where they used to have a relationship with a business and they no longer do, and then they suddenly get some marketing communication out of the blue after a year or two or whatever, and they think, oh, what's this? I didn't consent to this. Receipt of such marketing where they never had a relationship with a company. And it's possible that, maybe they did have a relationship with a company and they agreed to receive marketing material from their business partners and affiliates and that, and then that's what they get. And they don't recognize the name. They can't match the name to maybe the original business they had a relationship with. They could not find a means to unsubscribe on the email. They attempted to so there was an unsubscribe. They attempt to unsubscribe or even delete their information, and it's repeatedly unsuccessful. And then there's the final category where it's a complaint about receipt of possible spam email text, which may have a malicious kind of angle to it. So how do we triage those? Okay, so they all come through our intake team. And the first thing we look at is who has the individual dealt with the company? So did they go to the company with their issue? And, is it at the operational level, for example, customer care or, whatever it might be? If they have done that, we would typically direct them in the first instance to a company's privacy officer, because to allow the company to try and resolve the matter first, that's our preference. That's how we like to go, is give the company a shot at resolving the matter first. If the matter is of interest to other CASL enforcement partners, CRTC and OPC, we may recommend that the individual also report the matter to the Spam Reporting Centre. And that way, then all three agencies can access the information, and we can compare it to other information that may have come in from other sources about the same mailing, the same client company. If it's with regard to unsolicited telephone spam, unsolicited telephone calls, we may or usually refer the individual directly to the CRTC, which enforces the unsolicited telemarketing rules and a do not call list in Canada. So we will do that. So because they have the mandate. Regarding complaints about potential scam emails and SMS texts, we typically will recommend an individual inform the Canada Anti-Fraud Centre and all relevant law enforcement. But if after all of this, they refer the matter to the company, the company's privacy officer, and they come back not dissatisfied, we will take the matter up with our early resolution team. And this is a more informal approach to compliance and is, in our experience, highly effective at reaching satisfactory outcomes without the need for a full resource-intensive investigation. So typically, we can resolve these kind of matters in a few months, but with mutual agreement between the parties. And again, that's very effective. We close more than 80% of our complaints up. So I'm just on the last 3 slides, so I'm conscious of the time. So I thought I'd cover a few activities of interest that may be interesting to your industry. So the first one is, I know there's a lot of discussion around AI during walk, quite rightly here as well. So what you may not be aware of is in December 2023, the OPC and our provincial and territorial counterparts published the principles for responsible, trustworthy, and privacy-protective generative AI technologies. And so it just recognizes that while generative AI poses novel risks to privacy and raises new questions and concerns about the collection, use, and disclosure of personal information, AI does not occupy space outside of current privacy legislation. It still applies. I know we haven't got the Artificial Intelligence and Data Act. In the meantime, we do have PIPEDA and our provincial equivalent legislation. So organizations developing, providing, or using generative AI are obligated to ensure that they comply with existing privacy laws and regulations in Canada. So we set it out by principles. I won't say it's a checklist, but it's kind of like questions to ask yourself. It's pretty useful stuff. But it doesn't obviously exhaustively reflect all compliance requirements. We still have to conduct investigations from time to time, adjudicate on matters. So just to say, it's useful information. The other one I wanted to talk about was in August 2023, we issued a joint statement with other international agencies to social media companies and operators of websites that host publicly accessible personal information. And what we said, our expectations around them protecting unlawful data scraping, data harvesting. So we had significant engagement with the very large social media companies and key industry players, and a concluding statement on this issue is imminent, with further lessons learned from our engagement with each of these companies, and to keep an eye out for this in the coming weeks. And my final slide is a introduction segue to Derek's presentation on cheap and sweep of deceptive dark design patterns or dark patterns. So dark patterns are design choices that organizations deploying websites and mobile apps to influence, manipulate, or coerce users to make privacy decisions that aren't in their best interest. So I know Derek's going to talk about that immediately after this session with its relevance to e-marketing. So I'm looking at a kind of higher level picture here. So the sweep was coordinated by the OPC and took place between January the 29th and February the 2nd, and it involved 26 data protection agencies from across the world. We reviewed 1,000 websites and apps, and we in Canada reviewed 145 websites and apps, including 67 targeted at children. Now, the shocking thing was that the sweep found that 97% of the apps and websites we reviewed, regardless of the industry, age that they're aimed at, whatever, were using one or more of 5 deceptive design patterns with the public, including long and complex privacy policies, confusing and leading design, interfering with privacy choices, nagging users to provide their personal information, trying to get off the website's a good example. You want to delete your account. Are you sure you want to delete your account? Please take this extra step to delete your account. Please contact these people to delete your account. Are you sure you really, 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 really want to delete your account? So there's a kind of click engagement fatigue there that kind of sets in. And so they're hoping that you don't delete. So further details of the sweep's findings, including the OPC and the GPAN report, are on the website, OPC website. And this was the first sweep, this is interesting, that was conducted with the Consumer Protection Agencies. So we, 26 agencies on the privacy side, and almost the same number on the consumer protection side, were looking at it from different angles and came up with similar conclusions. So pretty interesting. And IcePen have also issued their report. So conscious of my time, just to summarize there what I did. And I'm reckoning that we probably don't have much time for questions, but let me say that I will be here for Derek's presentation, and I'll be here for the coffee breaks. If you want to approach me with like specific questions, I can do that. Or if you want to feed them through Matt, I'm sure he can bring them up with me.
Derek said he'd let me give you one question.
Okay, you've got one question.
I don't know if you can provide any insight into this at all, but one of the key things with CASL, it's a rigorous law. It's one of the top in the world, but it needs to be applied by everybody.
Opt-in unless exceptions.
Yeah, exactly. There's fines associated with it, and
Yeah.
it was originally private right to action built into it as well.
Yes.
Which is, to me, the real teeth that had industry justifiably paying attention.
Yeah, that's suspended, I think, 1 month before it's due to come in July 2017.
Yeah, exactly.
Less than a month.
Yeah, it's 3 weeks before. Do you have any insight into that possibly coming back, or where that is?
None of it. I really don't know. It just
Even off the record?
no, even off the record. I haven't heard any recent news about it as well.
Take one more question.
The actual language was an indefinite suspension,
Yeah.
which meant it ain't coming back.
Oh, I can't speak to that. Yeah.
Yeah.
One way or the other.
You threw up a slide that mentioned all the various things that Canadians are reporting.
Yeah.
Right? So unsolicited or unwanted email, fraud, that kind of scams. I'm curious, it would have been interesting for me to see the percentages associated with each of the complaints. I think that would be interesting, but I'm wondering if maybe high level you could let us know like what proportion is fraud related or
Oh, you mean the
scam
ones
related?
that we see at the OPC
Exactly,
that are
exactly, the
charged?
ones that you're seeing being reported, and then which one,
It would be a very small percentage. What you see, basically what's happening is the reason I think we get direct complaints as opposed to them going to the spam reporting center is because, you know, some of these complainants may be familiar with the OPC, they may have made complaints to the OPC before, and so that's the entity they know, and that's the reason they approach us, even though it may not be the appropriate, we may not be the appropriate.
so you're
thing.
seeing more unwanted or unsolicited email versus.
More, kind of legitimate email, but just unwanted or inability to answer.
The CRTC provides a twice annual report.
Yeah.
Talks about the breakdown, what they see, the number of complaints they receive, etc. So you can get them on the CRTC.
Yeah, because they run the spam reporting center, so they see the huge picture.